And I truly believe that he had not made up his mind. He only began to think about it after he got on the court. I have to say he and I have become very close personal friends after that. But everything I know about him as a friend is completely consistent with what I observed on the bench. He recommends to all of his law clerks and his friends certain books that you should read, and one of them is he actually turned me on to Anthony Trollope. I've always been a Dickens fan. I'd never been particularly fond of Trollope. The particular book is a book called Dr. Thorne, and the first time I read it, I thought, what is this about? I don't understand why he would recommend it so strongly. And then he explained it to me. It's because the author deals with, as with many Victorian novels, many, many characters, and some bad and some good in all of them. And as Justice Souter explained, the author is so fair in how he treats every character and how he depicts the person, showing some element so you can identify or empathize with something in every single character. And even the person who might at first glance seem venal or evil or greedy or malicious, you see some saving grace. And that's the way he is. I mean, a completely fair person. Fair in judging every issue freshly and every person freshly, and he came, despite those who sponsored him, he came without an ideological agenda. He left without an ideological agenda. I think it's a wonderful coincidence that his very last decision for the court was a wonderful victory for the ACLU in a case in which we were representing Savannah Redding, who was a 13-year-old, you've all heard about this case, a 13-year-old girl who was subject to a strip search in her public school because she had been falsely accused by a kid who had been apprehended with some illegal, when I say drugs, it sounds too bad, you know, prescription strength ibuprofen. Some of us think that should not be outlawed in the schools. Anyway, but putting that aside, on the allegation of this student who was in trouble, our client was subject to a strip search, which was very, very humiliating. And even though the Supreme Court has been very bad recently on students' rights and on Fourth Amendment rights of privacy against search and seizure and anything to do with the war on drugs, the plaintiffs tend to lose. I was very nervous about how this case would go, but we won it 8-1, and Souter wrote a wonderful pro-privacy opinion for school students.
Now, do you feel, as you just mentioned, since Souter is stepping down, I think a lot of us were surprised when we heard that he was the justice to be stepping down, because you know, as soon as Obama got elected, a Democrat in office, I said to myself, and a lot of my constitutional law class said to themselves, Stevens has got to be the one to step down. Could we expect that in the future? It doesn't seem like he's slowing down at all.
He seems extremely vigorous. I don't know him personally, so I can only report what's publicly observed. The last time I saw him make a public presentation was at the inauguration, and I thought that Stevens, he certainly did a better job than John Roberts, who's like half his age. Roberts kept garbling the oath of office repeatedly to the point of having to do, and Stevens had absolutely no problem doing it. And he loves what he's doing. He obviously is thriving on the job. Whereas Souter was doing it, he loved his work, but he was so homesick for New Hampshire and for, he hated the, you know, the glitzy aspects and the political aspects.
Doesn't have a television, doesn't have email, right?
Yeah, exactly. And his house is rather modest, but it's his home, right?
In terms of, you know, future decisions that will be made on the Supreme Court, I understand you're saying that there won't be an ideological shift, but do you feel that Sotomayor will be able, is kind of in the same wavelength as Souter?
Absolutely, sort of what I would call a moderate to liberal, but also seemingly a very fair-minded person. Now, I mean, certainly a very fair-minded person. The hallmark of her rulings as a lower court judge has been completely meticulous attention to the facts and the law and the precedents in every case, which is why you don't see any sign of result orientation. It's not like every civil rights plaintiff wins. As I said earlier, it all depends on the facts and it all depends on the precedent. And by the way, on the white firefighters case, as most people know it by that name, the Ritchie case, the reason why the Second Circuit on her panel ruled the way they did was that was the way the law was. The U.S. Supreme Court reversed because it changed, and it admitted that it was changing what the law had been. So she was always very carefully following precedents. Now, when somebody is elevated from a lower court to the Supreme Court, they're no longer so hidebound by precedents, because the U.S. Supreme Court does have the latitude to change its own precedents, and we are very familiar with important times when they've done that, like Brown versus Board overturning Plessy versus Ferguson. So what we don't know is, once she has a little bit more leeway, how she will rule on some of the big issues, which she hasn't had a chance to pronounce on yet. But so far, every indication by way of temperament and background would certainly indicate that she's very much in that center to left spectrum. And with one possible difference from Souter that observers are projecting, again with all the caveats that we can't know, it's quite possible that she might be less sympathetic to defendants' rights and more sympathetic to the prosecution in criminal cases. And one of the things that has fueled that speculation is that, you probably know, at the very end of its term, the Supreme Court decided a case on the right of an accused to confront the evidence against him. In particular, this had to do with getting to the scientist who had prepared a lab report that would be introduced into evidence. And the court, 5-4, upheld the defendant's right, and then immediately granted cert, agreed to review virtually the identical case at the very beginning of his next term. Well, why would they do that unless there were some folks on the court who think there's a fair chance that Souter voted for the defendant, a fair chance that Sotomayor would come out the other way and reverse that precedent very quickly.
Now, last question before we wrap up. Do you think with this white firefighters case, as everybody's calling it, do you think this is a shift away from affirmative action? Do you think that will be something that will be more tempered in the future on the court?
Oh, I think that's been true since Sandra Day O'Connor stepped down from the Supreme Court. One of her last rulings during her last term was on the University of Michigan affirmative action cases. It was a 5-4 vote in which O'Connor was the key swing vote, upholding affirmative action justified on diversity grounds in higher education. And I think it's extremely unlikely that her successor, Samuel Alito, would vote the same way. Now, Souter was in the pro-affirmative action camp, so even assuming Sotomayor is too, I think the change between O'Connor and Alito has already sealed doom for affirmative action.
Okay.
Thank you very much.
Thank you very much.
And again, this is the media reporter at New York Law School. We want to thank Professor Nadine Strossen for joining us today, and please, hopefully you will join us again next time. Thank you.
Thank you.